Welcome to On the Ballot with Ballotpedia, where we connect people to politics by providing neutral, nonpartisan, and reliable information on our government, how it works, and where it's headed.
Hello, everyone, and welcome to another episode of On the Ballot. I'm your host, Norman Leahy. I'm a senior editor here at Ballotpedia, and of course, in the ongoing coverage that we do as the Encyclopedia of American Politics is cover the court system, and in this case, major cases before the Supreme Court. One of those just was heard the day after Election Day on November 5th, and it has I guess you call it an innocuous title, Learning Resources Incorporated versus Trump. Sometimes innocuous names mask large constitutional issues. And to help me walk through those constitutional issues is Liza Goitein. She is not only an expert in all kinds of federal law, but she's also a senior director of the Brennan Center's Center for Liberty and National Security, or their National Security Program, I should say. Elizabeth, welcome to the show.
Thanks for having me.
And yeah, this Learning Resources Incorporated versus Trump. There's a big issue under this. Tell us about it.
So this is the challenge to President Trump's tariffs that he has imposed on nearly every country in the world. What happened is that starting on his very first day in office, President Trump issued a series of national emergency declarations. And those declarations enabled him to invoke an emergency power that's called the International Emergency Economic Powers Act, or IEEPA. And IEEPA is available to the president when he declares a national emergency, and then and when there is also an unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. So President Trump made that finding that there was this unusual and extraordinary threat. In the case of Canada, Mexico, and China, the threat was fentanyl trafficking. In the case of the tariffs that he imposed on nearly every country in the world, it was our long-standing, decades-long trade relationships with these countries. In some cases, it was a trade deficit, a trade imbalance where we were, obviously getting the short end of the stick in the president's view. But even with countries where we have a trade surplus, he still said it was an emergency because the surplus should be bigger. And based on, I'm not making this up, and so based on these findings, the president invoked IEEPA, which gives him a long list of economic tools that he can use to respond to the threat in question, and he used that to impose the tariffs. Starting at 10% and going up as high as 50%, depending on the country. There were lawsuits, obviously, that were brought by several companies and also states that were impacted by these tariffs. In the lower courts, the courts have pretty much ruled for the plaintiffs in all of these cases and have struck down the tariffs. So the administration appealed to the Supreme Court. Because the lower courts have stayed their rulings pending appeals, that means the tariffs are still in place, notwithstanding their rulings. This is not on an emergency appeal. I know we've seen a lot of those from the Supreme Court. This is sort of on the regular time schedule, although all of the parties agreed to an expedited briefing. And that's why this was the first case that was heard by the court this term.
So the lower courts have ruled against the tariffs.
Yeah.
The Supreme Court is going to decide their constitutionality under IEEPA. What was the administration's main argument before the justices?
So I think before I tell you the administration's argument, it's probably more helpful for me to tell you what the plaintiffs have argued, because a lot of it is sort of in response.
Okay.
What the plaintiffs argued was and the amici as well. That's the friends of the court that filed briefs in these cases. What they argued was that, first of all, the predicate conditions for invoking IEEPA had not been met. And that there wasn't an emergency. Now the National Emergencies Act, which is what authorizes these declarations of emergency, doesn't really define emergency, but obviously it does have a definition. And the definition of an emergency is a sudden and unexpected crisis. And in this case, the president was talking about decades-long trade relationships as the opposite of sudden and unexpected. Similarly, the plaintiff said there's not an unusual and extraordinary threat. It can't be unusual and extraordinary if it's every country in the world, and this is a status quo that we've had for decades. So, but mostly I think the plaintiffs focused on this law IEEPA and whether it actually authorizes tariffs because, as I said, there's sort of a long list of actions, economic actions the president can take, but it doesn't anywhere in this list include the word tax or duty or any of the words that specifically relate to tariffs. And in other situations, I mean, it does say the president can regulate and there's a long list of things he can regulate that includes importation and exportation. Um, but what the plaintiff said is, look, in every other case where Congress has authorized tariffs, Congress has specifically, with one possible exception, Congress has specifically said tariffs. And one of their main arguments was actually a doctrine that the Supreme Court has really embraced and relied on very strongly in recent years, which is the major questions doctrine. And this is this idea that when the president acts in a way that has major economic or political significance, his actions have to be clearly authorized by Congress. They can't just be implied. And so what the plaintiff said is, look, this is if you're going to continue, if you're going to apply the major questions doctrine in all these cases, this is really the one of the places where that doctrine should be most applicable because the political and economic significance of these tariffs is so great.
But that's one thing that I saw. You mentioned it
Mm.
in your discussion there. Uh, Everything I've read about this case and how the arguments went seemed to me like it was less of a hearing of oral arguments and more of a grammar rodeo in which the court was trying to decide what the word regulate means. Am I reading that wrong? Did they spend a lot of time trying to suss out what that word really means?
Yes, because that or what Congress intended it to mean, right? I mean, that's really the important thing is what was Congress's intent? And that, the heart of this case is really going to be whether IEEPA authorizes tariffs. And that all hinges on whether this word regulate can be read to mean tariff. And the court doesn't just look at sort of the dictionary definition of regulate, right? The court also looks to things like other laws that Congress has passed, as I mentioned.
Sure.
There's also the fact that when Congress passed IEEPA, Congress had fairly recently passed a sweeping trade bill that had several different provisions for tariffs. And again, these were explicitly talking about tariffs. They were in situations involving balance of payment issues and trade deficits, harm to domestic industry, all of the things that the administration is now saying can fall under IEEPA, essentially. And so, the question is, did Congress really create a brand new sweeping tariff authority without specifically saying so? Just a couple years after it had, a few years after it had enacted this very broad trade authority.
So what you're, I think what the underlying thing you're explaining there is a balance of power. Who has the power to do what? And it seems like for laymen like me, the Constitution's very clear on who has certain power to do certain things. But this case might potentially scramble that. At least our I guess the commonly accepted version of the presidents do this and Congress does that and they check each other. What 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 does this mean? What does this mean for the balance of power in the federal government?
Right. So, I mean, that is really the question here, right? So, the power to impose tariffs is part of Congress's, not only is it part of Congress's authority under the Constitution, it is actually the first power that Congress is given in the Constitution is to lay and collect taxes and duties and imposts, and that those are tariffs. And now Congress can delegate some of this power to the president, and in fact has, right? So there are all these different laws that allow the president to impose tariffs, but these laws come with certain conditions and limitations. And so, what is happening here, and this is the crux of the plaintiff's argument, is that President Trump is trying to get around these limitations and these conditions in these tariff laws by declaring a national emergency and relying on IEEPA, a law that doesn't actually use the word tariffs. Now, one of the arguments that was made, and in fact, a federal appeals court agreed with this argument, is if IEEPA can be read as essentially a limitless delegation of authority by Congress to impose tariffs whenever the president wants or functionally whenever he wants and without limitations, without conditions. If it can be read that way, that would actually be too much of a delegation. That would be unconstitutional because Congress would basically be taking the entirety of its power under the Constitution and handing it to the president. And so that issue of balance of powers is absolutely central to this case.
So from what you just said there, if the Supreme Court decides to rule against the administration and uphold the lower court rulings, it is saying this is what the law says, this is how the Constitution functions. No, you can't use IEEPA to do these things because that power never existed, correct?
You can't use IEEPA to get around the law that Congress has passed, and you can't use IEEPA to usurp a power that the Constitution expressly gives to Congress.
And then on the other side of that, what if the court says, the lower courts are wrong, the president's right? What does that look like?
Well, one of the critical things to understand about that is there is no way that the Supreme Court can uphold these tariffs without accepting that there is a national emergency here and that there is an unusual and extraordinary threat. And that could happen in a couple of different ways. Either the court could agree with the administration that it is not allowed to review those questions. That is the position that the administration has put forward, that the courts have absolutely no role in assessing whether or not there is an unusual, whether the president has followed this legal requirement that there be an unusual or extraordinary threat, um, or any role in determining whether an emergency has been properly invoked. So the Supreme Court could say, yeah, we can't look at those questions. Alternatively, the Supreme Court could find that it is allowed to review the questions, but that it has to apply a degree of deference that is so significant, so substantial, so much deference that it can look at something that has been in place for decades with countries around the entire world and say, that's an emergency, that's an unusual or extraordinary threat. And frankly, if the court uh, gives the president that much deference to say that worldwide, decades-long trade relationships are a national emergency and unusual, extraordinary threat, that would essentially mean that the president can declare an emergency anytime. That would be the functional equivalent of not reviewing um, those particular aspects. And so, if the Supreme Court essentially one way or another says we can't really review whether there's an emergency or an unusual, extraordinary threat, that's incredibly dangerous
And to be
because
and to be clear too, I just wanted to interject this. The Brennan Center did file a front of the court brief on the side of the plaintiffs.
that's correct. And what one of the things we argued in our amicus brief is that the history of the National Emergencies Act and the history of IEPA show that Congress intended to rein in the president's use of emergency powers with these laws. That the president was not trying to give the president a blank check or to give him absolute discretion. To the contrary, the court was worried that Congress was worried that presidents had been declaring emergencies and using emergency powers when no actual emergencies existed. And so Congress was trying very hard to rein in the president's use of emergency powers. And it is simply inconsistent with the clear intent of Congress to say that the president has absolute discretion here, that no court can review that discretion. And it's also inconsistent to say that IEEPA should be read incredibly broadly when the purpose of IEEPA was to rein in presidential power. So one of the things that's really concerning here is if the court uh, holds that courts can essentially, as a practical matter, not review claims of that there's a national emergency. When the president declares a national emergency, there are 137 different laws that become available to him. IEPA is only one of those laws, and some of those laws are incredibly potent and have uh, and have a really there's a really alarming potential for abuse with some of these other laws.
So, as I said at the top of the show, innocuous sounding cases can contain very substantial constitutional questions, and that's no different here. And I know it's a sucker's bet to say how the court might rule, but what's your first impression?
Yeah, well, it was interesting to me because I would say at least 3 and potentially 4 of the justices, seemed pretty skeptical of some of the administration's main arguments. The administration was talking about all the deference that needs to be accorded to the president in matters of foreign affairs, and we would expect Congress to delegate very broad powers in foreign affairs. And the justices, starting with Justice Roberts, really push back on the notion that this is all about foreign affairs. And they said, look, this is a tariff is a tax. It's a tax on Americans. So this is not your sort of quintessential foreign affairs case. And this is a power of Congress, not an Article 2 power of the president. And they also seemed, Justice Barrett in particular, really focused on the fact that Congress just hasn't used this term regulate in other statutes to mean tariffs, and that when Congress imposes tariffs, it says so. So across a range of issues, across a range of arguments that the administration had made, we saw pushback from conservative justices. Now, they also had some tough questions as well for the plaintiffs. And I don't like to speculate. But if I were the administration, I'd be nervous after the arguments on November 5th.
Well, we will find out at some point. We're not sure when an opinion will be issued. Is that correct?
Oh yeah, we don't know that, and I'm
Okay.
not even going to speculate on that one.
Right. And one last lightning round question. There are two other things that at least I have my eye on. One is a voting rights case coming up out of Louisiana, and another one was just accepted very recently, a case out of Mississippi about mail-in ballots, which I think is going to get back to this definition of terms. What does election day mean? So, any hot takes on those before we
Well,
wrap this?
for that, you'd have to ask some of my colleagues at the Brennan Center
Okay.
who work on the voting issues. That's a little outside of my lane, but I definitely have some colleagues who would be delighted to talk to you about that.
Well played. Well played. And I wish more of us did that. But Elizabeth Goitein, thank you for joining us from the Brennan Center's Liberty and National Security Program Senior Director. Thanks for being on the show. Appreciate it.
My pleasure.
And for the rest of you watching, listening, yes, you can get this podcast wherever you get podcasts. Of course, you can see us on YouTube as well. And we'll be back soon with another episode of On the Ballot. Until then, I'm Norman Leahy, and I will see you on the digital pages of Ballotpedia. Take care.